name is Chris Larson. I'm an attorney at Halverson Law. My practice primarily focuses on transactional business law with a little bit of an emphasis on the cannabis industry. Today I'm going to talk about how do I purchase or acquire an interest in a marijuana license. It's one of the most common transactions that we tend to see day in and day out. And I'm going to limit this discussion specifically to producer, processor, and retail licenses, primarily because other licenses are still available from the Washington State Liquor and Cannabis Board, where these three licenses can no longer be obtained via any avenue other than an artificial secondary market. There's two primary ways that one can obtain a license to produce, process, or sell marijuana at the retail level. You have a purchase of an actual business that holds a marijuana license, so that would be purchasing all the equity or all the membership interest in the business. Alternatively, you can actually purchase the marijuana license as a standalone asset, which is also referred to as an assumption. Purchasing the business membership interest or shares in a company is the traditional way to go about doing this, primarily because the LCB previously restricted the sale of licenses as a standalone asset. The mechanism by which you can purchase a business, typically in our office, it's most commonly done with an LLC, is via a membership interest purchase agreement. You've got a buyer who purchases all of the membership interest in a particular LLC from an individual seller. In this instance, a buyer essentially takes over the entire business, including all assets and all liabilities. The necessary form to do this, once the contract has been agreed to, is what's called the Change in Governing People, Percentage Owned, and or Stock Unit Ownership form. This is a form that's available via the Washington State Liquor and Cannabis Board, and it essentially just identifies who the new owner of the company is and who the owners are that will no longer be listed on the business or license. These transactions tend to be fairly simple because you are purchasing everything that the company has, all of its assets and all of its liabilities. However, it can be very complicated in the sense that you are taking on the existing liabilities of the company. So whether that be debt, prior violations by the marijuana licensee, really anything else that company may be enduring, you are stepping into the shoes to operate and to handle. Some of those things can be dealt with in the purchase agreement, but for the most part, you are taking the company as is. The second way to go about getting a marijuana license, which is a little bit more of a new approach because it previously, as I mentioned, was prohibited by the LCB, is the assumption of a marijuana license. You are actually buying the license as an asset, as a standalone asset of the company. What we put together is an asset purchase agreement, wherein the buyer purchases the license amongst other items necessary to operate the license from the seller. So in this case, the buyer would typically set up their own company, preferably or commonly an LLC, and they buy the marijuana license outright from the seller. This is done, as I mentioned, with an asset purchase agreement, and the necessary form that gets submitted in this case is actually a business license application. So the newly formed buyer's entity will submit a business license application in which they note they are assuming the specific marijuana license, whether that be producer, processor, or retailer, producer and processor. This is obviously beneficial because unlike the membership interest purchase agreement, the asset purchase does not come with all the same liabilities. If there's violations attached to the license, not in all cases, but many a times the violations will not follow with the purchase of the marijuana license. However, this can be also complicated because if you're only purchasing the marijuana license, you are then responsible for all of the ancillary services or requirements to ensure that you you can actually operate. So whether that be bank accounts, insurance, having a right to real property. Some of these things can of course be included in the asset purchase agreement, but as opposed to just stepping into the business, like with the membership interest purchase agreement, here you have much more responsibility for getting the company up and operating in the manner that you want. The most important thing to keep in mind with any of these is you are working with administrative agencies, and so the timeline is not just a matter of negotiating the contract, signing the contract, and having access to operate a marijuana license. The buyer needs to be vetted and approved by the Washington State Liquor and Cannabis Board as being permitted to actually own and operate a marijuana license. And that process can take no less than 30 days, sometimes up to 60 days, and in rare circumstances significantly longer. It's unfortunately not uncommon to see these take upwards of 6 months if either one side or the other doesn't have all of the necessary items lined up. In any instance, whether it be an asset purchase agreement or membership purchase agreement, proper due diligence is absolutely necessary. Not only is it necessary to determine that you have the means to purchase a marijuana license, but also determining which license you actually want to, or which method you would actually like to utilize. Whether you want to step into the shoes of an existing business or purchase the asset as a standalone item. Thank you for watching our video. I hope you're able to take something away. For more Halverson Law information, please subscribe by hitting the button below, or please check our website, halversonlaw.com, where we will post regular blogs, and we hope that Halverson Law can suit your legal needs. Thanks.